This show furnished by Karl Gerber and Employment Lawyers Group.
Since 1993, the Employment Lawyers Group has been a consistent force in fighting for the rights of California employees. They've represented thousands of employees in cases in which they've lost their jobs, been sexually harassed, discriminated against at work, or owed wages individually or as a group such as a class action. The Employment Lawyers Group has maintained a high win rate and a serious record before the California courts. Please call 877-525-0700 for an experienced work lawyer. That's 877-525-0700. They have call takers standing by. Online, research the firm at worklawyerca.com. They have offices throughout Southern California. If you hire the Employment Lawyers Group, your legal problem becomes theirs to solve.
Earn your wrongful deeds, so once again, you've been charged. My lawyer filed a lawsuit for wrongful discharge. You might fire me for
Talk Radio 790 KABC. You're listening to the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, and in real life, I represent employees, and I promise that after the first of the year, we'll be back with scripted comedy, but we're going to be covering some real things today, if you can believe that. Real labor laws coming out for 2019. We might even hear about the new client calls at my office. I also have a guest here, but before we start, I got to tell you, recently, guys, I was in Bakersfield on the outskirts of town. I got to eat lunch, and I've heard about this place, and I want to try it. The parking lot's all dirt. An F-150 with super big wheels pulls in ahead of me, and he parks diagonally, stirring up enough dust to get me coughing for a month. No biggie. I've got a F-150 back on the ranch. Almost in procession, a giant-wheeled Dodge 2500 truck pulls up diagonally alongside the F-150. No biggie. I've got the diesel model with an 8-foot bed back at the ranch in Studio City. And I'm in a Dodge Challenger with almost 500 horsepower, so I'm feeling all right in Bakersfield. So a Latino guy about 5 feet tall gets out of the humongous Dodge truck. For a minute there, I was getting a little concerned. I was going into some super white supremacist institute to eat lunch. I'm not wearing a tie yet, and my jacket isn't on. That's cool because it's over 100 outside, and you can smell it when it's over 100 in Bakersfield. I go into the first door I find. I'm in the middle of a completely dead bar. A white bartender on the other side. Clearly nothing in him but white power. Where is a Latino guy when I need him? The place is old as me, from 1969. It's in Bakersfield, so you just know it's got to have a racist past. I see some hair fragments on the walls from bar fights of long ago. I can't tell if it's my people's hair or it's even nappier. It's over an hour and a half at 75 and then 80 to Bakersfield from Sherman Oaks, where I usually work, and I've got to use the can. Plus, I want to get out of this bar. I see this sign, and there's a 94-pound jackhammer blocking the entrance. And it's got a sharp, pointy bit on it. I pick it up with one hand, swing it with two fingers so the grease doesn't get on my Versace pants. The bartender nods. I'm feeling like I might not get jumped in the can. I walk into the bathroom, and the lights don't work. My Apple 10 is all illuminating the walls, and I see some cryptic graffiti. One urination station says, oh, that's just disgusting, peed here. And the other says a Jew peed here. So I go over to the urinal that says the deplorable thing because I don't want to be too obvious and pee in that one about the Jew. So I keep checking my back, and I'm done. I walk out, and there's this black lesbian standing there who says she's the owner. I tell her, "Hey, Whoopi, what you trying to do to me? I keep thinking I'm going to get a whoopee in this place." She says, "Sorry, I knew you were coming and just wanted to mess with you, and maybe we can do some anti-racist comedy thing together." Whatever. Did it happen to me in Bakersfield? I don't know. So I've got a guy in studio. I know him because he did my overflow cases, and I think that this is Ben Rothman, not Ben Shapiro, right?
Right.
Nothing to do with Ben Shapiro?
Nope, nothing.
Ever met him?
He was in one of my classes, I think, when he was like 11 years old at UCLA.
What kind of class were you in?
It must have been a poli-sci class.
So you actually went to college?
Yeah, actually.
Oh, at UCLA too?
Yeah.
You know, I was born at the UCLA hospital a really long time ago.
That's great.
No, not really, because Like, I don't go back there and check it out, and I don't think that hospital's there anymore. I think it's a new one. But so are you a lawyer?
Yes.
You really are a lawyer because you handle my overflow cases.
Right.
And I knew that you were Ben Rothman, and I knew that you went to college, too. We were both political science majors. Isn't that a coincidence?
All right.
So, I don't really know. There's a lot of stuff going on in law lately, and there are a lot of questions coming up. One of them that you asked me to talk about on this show is, the strippers get to keep mandatory service charges.
They do.
How do you know this? Just based on experience?
I read about it.
You just read about it. You never had an experience with, dating somebody who worked in a club and then you found out they had to keep a charge?
No.
Okay.
Not me.
So where did you read about this? Like, because you know what's interesting is now on the streets, like you see where there used to be newspapers, the Daily News still sells newspapers, but that's usually the Hollywood Reporter or LA Weekly. So I'm assuming you read about this in the Hollywood, not Reporter, the Hollywood Star.
No, I didn't read about it in anything that was free.
You actually paid to read this?
Well, actually, you can find a useful article about this at SantaMonicaInjuryLawyer.com.
No plugs for websites, and you're supposed to be an employment leader, lawyer, whatever. Anyways, but see, here's the deal. It may be true that they are supposed to keep a mandatory service charge, but I don't think that always happens.
Well, no. I mean, there are ways around that.
I have represented exotic dancers. I had a case some years back before they all went to binding arbitration. It was one of the original gentlemen's clubs, I think in El Monte. And it was strange because we had a mediation and the owner had already died, but the wife died the night before walking. And so it was just that we didn't know this. It was just odd. Life really is as strange as my show. And so we have a mediation. The ladies actually were okay. They really weren't what you'd expect. And one of the things that they told me, one of my clients was pregnant, by the way, and she got fired because she was pregnant. And I thought that maybe that would be an occupational problem, being an exotic dancer and all. And I think it was not fully nude because they didn't serve alcohol there. But she told me, and all the other ladies told me, that if you're pregnant and you're working as an exotic dancer, there's a much better tip possibility. And a lot of people, not a lot of people, but some people, I'm not just talking about Remus Helms. I don't know if he has this or not going, but a lot of them are interested in pregnant women. So some men will request. Oh, Ben is nodding his head. Is this something you're into?
No, I was just imagining one of the reasons would be you can't get them pregnant. They're already pregnant.
Oh, man, that's completely illegal. That's completely illegal. But I had another case. Okay, my client Rachel, I'll keep it at that. She wasn't actually Jewish. She was Latina, but Rachel is a Jewish name. So Rachel refers me her brother who was working for, there's a really big one. I'm not going to say the name on the air. They're nationwide, and they, of course, did have a binding arbitration agreement. But he did things in the club. He's obviously not a dancer, and he had to pick stuff up, and he said there were a lot of spent items on the floor, and he felt this was very unsanitary. It was a health hazard, and he complained about it, and that's why he might have been fired. So I guess that kind of stuff, it does go on in those clubs. I don't know. I don't go to them, and I have experience with pregnancy through representing pregnant clients, and of course my wife that I don't kiss, but she and me, we have 2 kids that we naturally conceive. So I knew her when she was pregnant, and we were married and stuff, and that's all I can say. So I guess, okay, so we've covered this, that there's a mandatory service charge that the exotic dancers should keep. I don't know, I don't even know if there is a mandatory service charge at those clubs, and I don't even know why the exotic dancers would get it. This is something Ben read. I thought you'd tip them if you had like a really good time or something. You're supposed to tip them. I don't know. I don't know. Once, and it was 20 years ago, I went to one of those places with my friends, and quite a few of them were lawyers because one of them was going to get married, and we went to check out the club. I don't know why we did that for a bachelor party. We could have just had the bachelor party there. But okay, so that's that. We've covered that. The other thing you asked me is, can prisoners get workers' comp? Do you think we have prisoners listening to this?
Well, that's probably not happening, but I've gotten calls about this.
Well, why not? We've got a really weird audience. It's like a cult following listening to this show.
Some, maybe like the level ones might be able to have access to your show? They can live stream.
Oh, this is too heavy, man. It's too heavy for level 3 or level 4 prisons. I get it.
Right.
What about, because there's some correctional institutions that I seem to get involved in, not going there, but I've got people working there because I do really cover Bakersfield. And some of those are run by GEO, which is a private correctional institution group.
Yeah, they have a lot of them off the 5. It's the number 1 industry, I think, in Kern County.
It may be. So if you have a real employment problem, please call 877-525-0700. That's my office. 877-525 if you're owed money, including tips. 877-525-0700 for a real labor lawyer. You're listening to Karl Gerber, Workplace Lawyer Show. I'm Karl Gerber. You also hear Ben Rothman on the air. This is Talk Radio 790 KABC.
Holidays leave you strapped for cash? How does 4 shots at $1,000 sound?
Lord, that sounds good.
It's the $1,000 payoff on 790 KABC. Starting Thursday, listen for the national keyword weekdays at 6, 9, noon, and 3. Then text it to 95819 for your shot at $1,000 4 times a day.
Ka-ching.
The $1,000 payoff on 790 KABC, because politicians aren't the only ones that should be paid off. Rules and info at kbc.com. And please do not text and drive.
Let's do it.
Okay.
O-K-L-L.
On this week's Uncensored OKLA podcast,
Steve, Jillian, and me, Dorothy, try and get ET's Nichelle Durner a date.
and I reveal that journalists love chaos. The OKLA podcast, free, uncensored, and unmissable.
Download and subscribe for free on iTunes and KABC.com.
790 KABC.
O'Reilly. A rough-running engine could be suffering from buildup of fuel and oil deposits, but O'Reilly Auto Parts can help. Clean out engine buildup and improve fuel economy with Seafoam Motor Treatment. On sale for $7.99 each at O'Reilly Auto Parts. Better parts, better prices every day.
O'Reilly Auto Parts.
As a small business owner, you make every dollar count. So what could you do with $10? Go to Vistaprint.com today and you'll get 500 high-quality custom business cards for only $9.99. That's less than 2 cents per card. And at Vistaprint, your satisfaction is absolutely guaranteed. So it's never been easier to turn 500 strangers into connections. Just visit Vistaprint.com and use promo code 3838 at checkout. That's Vistaprint.com, promo code 3838.
Message and data rates may apply.
When did it become okay for men to be lazier, softer, fatter? We need to bring the men of this country back to greatness. And it's easier than ever with Ageless Male Max, a patent-pending formula with an ingredient that helps boost your total testosterone, promoting greater increases in muscle size and twice the reduction of body fat percentage than exercise alone. Plus, an amazing 64% increase in nitric oxide, which can be handy in the gym and in the bedroom. Take your manhood to the max by trying your first 30-day bottle free. Just pay shipping and handling. Not 10 days, not 15 days, but a full 30-day supply free when you text the word PRIZE to 797979. Finally, a formula that boosts total testosterone. If your results with Ageless Male Max are too intense, please decrease use. For your free bottle, text PRIZE to 797979. Text PRIZE to 797979.
Hey, this is Dr. Drew.
And I'm Lauren Savant.
We know you don't want to miss a minute of our show every day.
But you probably have a life. You may want to listen on your schedule. Well, you can.
Check out our daily podcast,
Dr. Drew, Midday Live with Lauren Savant,
on iTunes, TuneIn,
and KBC.com.
The Rick D's Dead 40 Podcast. Yes.
Musicians work hard to craft an image for their fans, but when their actions conflict with who they claim to be, we're left to wonder who they really were, especially when their death is still a mystery to this day. The real life and death story of Tupac Shakur.
When I die, it's gonna be no noise. You're gonna hear people screaming. I'm fade out.
Tupac, the gangster. and the poet. Now streaming as part of the Rick D's Dead 40 podcast on iTunes, TuneIn, and KABC.com/Dead40. Home of the smartest listeners in Southern California.
I am the smartest man alive!
Talk Radio 790 KABC.
Since 1993, the Employment Lawyers Group has been a results-oriented law firm whose goal is to get the client what they deserve. They've represented thousands of California employees who've lost their jobs, been sexually harassed, subjected to employment discrimination, or were owed wages on an individualized or group basis, such as a class action. They have a high rate of success. There are few situations involving employment law that they have not confronted. At the forefront of employee rights, they're often the first employee law firm to confront a new legal issue. For an experienced employment lawyer, call 877-525-0700. That's 877-525-0700. They have call takers standing by. Online, read more about the firm at employeelawca.com. They have offices throughout Southern California. Make your work problem theirs to solve.
A statute might apply to protect me if I did. But common law commonly does not forbid your unfair.
Talk Radio 790 KABC. You're listening to the Karl Gerber Workplace Lawyer Show. Tonight we have on Ben Rothman, who is my overflow lawyer. He gets inquiries from me about cases many times a day that our office simply can't handle because we get so many inquiries when people call us at 877-525-0700 for real labor lawyers. And if we can't do it, we know a lot of lawyers. We have a big network of lawyers who are appropriate for the case. 877-525-0700. Once again, 877-525-0700 for a California labor case. Before we broke, we were briefly talking about whether prisoners get workers' comp. I had a joke on one of these earlier shows about how the people listening, they hadn't done hard enough time and it was just petty offensive. And we discussed probably that if you're in a level 1 prison, you might be able to listen to the show, but because it's so racy that maybe in the level 3 and 4 prisons you can't. So I think we're going to move out of that. Another question Ben asked me to ask him is about bathrooms. He asked me, can an employer install cameras in the bathroom? What do you think, Ben? What have you read? What have you researched?
I don't think they can do it except under emergency circumstances. They might be able to get a court order to install a camera.
Why would they have a court order to install a camera?
Like maybe people are dealing drugs in the bathroom, or
I don't know if that would do it. I mean, a pedophile. I had people cases. I had a case with a restaurant of the fast food variety with a manager that made a peephole in the bathroom. And sometimes he stuck something in the hole, and it was kind of like, a Remus Helms kind of thing, but not quite like that. And he also, I think, was filming. And these cases, they're sick. One of my clients, when he did this to her, she wasn't even 18. The other one was somewhere in her 30s, I don't know, mid-30s, maybe late 30s at the time. But cameras should not be in the bathroom. I also had one case where my client was filmed going to the bathroom, and it was put on YouTube. The problem with the case is my client was laughing a lot when this happened, and the accusation by defense was that it was staged. I don't think it was. And he seemed kind of surprised, and I think someone, when they're embarrassed, might be laughing. But that's enough for bathrooms for the time being. I would say there's one of these questions, and it's political, so I'm a little afraid to ask it because, this is a conservative talk station, but a lot of people listening to my show, they're just kind of out there. They're hipsters, so I guess we can ask it. Can your employer fire you for being a Trump supporter?
No.
Why not?
It violates Labor Code 1101.
Political beliefs?
Yes.
Well, or is 1101 about being in an election?
That's more broadly interpreted.
I'm going to mispronounce this word. It's like proselytizing. Can you?
Proselytizing?
Yes. That's the problem. If people are doing that, religiously or politically, I do believe they can be fired.
That makes sense, but you cannot fire somebody just because you think that he's a Trump supporter.
And you know where this gets even stickier? If you're a government employee, I think it could get really difficult to fire people for expressing political opinions.
Right. But in the private sector, we're one of the few states that allows employees the right to their political beliefs, more or less.
Well, government cannot regulate politics, and government employees, in terms of religion, are somewhat more abridged. Those cases are complicated, and you may not be able to have anything up on your wall that is religiously oriented. And if it is going to be up on the wall, the city or the county or whatever branch of the government is really has to allow that kind of religious stuff up for every religion, or they're picking and choosing, which would be religious discrimination. Another question that you put on this piece of paper, which piques my interest a little bit, is, can an employee bring a pet to work? Now, as you know, on this show, we've covered organic ostrich, and we had, I think her name was Misha Dogma, and she, of course, did bring a dog to work. Many people brought pets to work. There were dog races. This was going on in the food processing area of ostrich, organic ostrich, and they also had other things going on there. We heard from Tanita Gravita I that they had battle chair ram and battle chair ram with makeout, which I guess you had to make out if you lost or something. So it was a really weird company, and it was completely fictional, but they certainly brought their dogs to work. I don't know about bringing normal dogs to work. Obviously, if it's a service dog, that's another story, right?
Well, believe it or not, you can bring just about any animal you want to work if you have a disability and a certification for it.
How would a snake help if you have a disability, and what disability would that be?
Anxiety.
The snake just makes you feel better.
Yeah, that's it. It's for emotional support. Actually, the law says emotional or other support.
So if it's just like wrapping around your neck and, you know, making you feel better, it's okay, even though it's creeping out, like the creepy doll. It's creeping everyone else out?
Well, it can't threaten their safety. But see, if it's, in your office in a tank, that's not going to hurt anybody.
Well, let's say it makes you feel better because it's a boa constrictor and you like the feeling of starting to constrict you. It just makes you feel warm and fuzzy and enclosed. But your coworkers are really getting concerned, and they don't want to get constricted, and they don't know how to stop the constriction.
Well, you need certification for this, for the need for that boa constrictor. So presumably the healthcare practitioner will not certify, a dangerous animal like that.
And I wonder if the employer could start challenging these certifications. They do that obviously in disability cases all the time when it's medical accommodation or something.
Exactly. They probably wouldn't allow you to bring, an elephant or something that's obviously going to cause a problem at work.
I have not had this case yet, and to be honest, I don't think I'm going to take it unless it's a seeing eye dog or a very serious service animal for a vet or something like that. I think it's going to get laughed at by a jury, and the jury is going to find it unreasonable.
Well, believe it or not, some nonprofits train certain animals as reasonable accommodations of disabilities. For example, there's one that trains monkeys for people who have spinal cord injuries. The monkeys can reach things on shelves, bring them to the person with a disability. So it might seem funny that a monkey is at work, but it might be a reasonable accommodation.
But whenever there's a safety risk, that becomes very tricky with these cases. I've read of cases where people have pet monkeys, they go away and they come home and the monkey has destroyed the house, or as soon as they see him, they rip out their eyes or their face. So, I don't know. I mean, I think that it really, a lot of people are afraid of dogs too, and it makes a lot of employees feel very uncomfortable if a lot of animals start showing up to the workplace. I have questions about sanitation too.
Well, they have to be able to eliminate, we'll say. So, for example, a cat has to be trained to use a litter box. The dog, maybe you have to take for a walk. But if it's something that you just can't control, it's going to go everywhere, the employer can put its foot down.
There are a lot of businesses where it's fairly regulated and people can't just go deal with the dog when it needs to because they're in the middle of pouring concrete or an assembly line or whatever they're doing.
You mean construction workers might not be able to bring a pet?
Well, I had a construction site a couple years back where somebody did bring a pit bull at work every day, and when I would eat there, it would want my food, and it was annoying. I was originally kind of scared of it, but I liked the dog, but I don't think that that's a great idea. I think it's a safety problem.
That doesn't sound like it was there to accommodate a disability, though. It was probably just like a tough guy.
It was probably a guy who didn't want to leave the dog at home. So it leads to more questions. And this is the workplace in 2019. And when we come back, we're going to talk about some new employment laws that are coming out for this year. Every year, tons of employment laws come out. It's hard to keep up with them. And that's why you really need to be represented by someone who just does employment law. Ben, I don't know why you're talking about some web URL with personalinjurylawyer.com. If you're in employment law, that's all you can do. There are too many cases, too many rules. That's all I do. I only represent employees in private sector employment cases. I can be reached at 877-525-0700. Once again, 877-525-0700, 877-525-0700 for a real workplace lawyer that can make the jury laugh and the judge not get bored and fall asleep. You've been listening to Karl Gerber, Workplace Lawyer Show on Talk Radio 790 KABC.
I really thought I would die of stress long before the cancer, because the diagnosis brought this avalanche of worries. The money, the travel, the burden on the family. One night I called the American Cancer Society, and they helped me map out a plan. Got me free rides to chemo and even a free place to stay during treatment. They took away those other fears, so I could rest up for the real fight.
Please give at cancer.org.
Geico presents eyewitness interviews with inanimate objects.
This is Belinda Collins, live on the scene of a recent lightning storm. Here to describe the event, a TV tray.
I was watching football and holding a plate of meatloaf when kabam! A bolt of lightning slams into the apartment, blowing out the TV and surround sound.
Anything you could have done to help?
Ma'am, I'm a foldable table, not an electrician.
Your TV tray can't help you in a lightning storm, but the Geico Insurance Agency can help you get covered for personal property damage. Go to geico.com to see how affordable renter's insurance can be.
If you think a Mercedes-Benz is out of your reach, it's not too late to take advantage of this year-end sales event at Fletcher Jones Motor Cars. Hello, I'm Fletcher Jones Jr. This is your best opportunity to drive your dream Mercedes-Benz for much less than you'd expect. And don't forget, our Fletcher Jones preferred owner benefits provide even greater value with complimentary airport shuttle and parking, car washes, and Mercedes-Benz loaner cars.
Visit us today to unveil your FJ offers. Fletcher Jones Motor Cars, Newport Beach. Experience the Fletcher Jones difference.
The workplace is a soap opera of relationships, rules, and labor violations. Hear about it Sunday evenings from 7 to 9 on Karl Gerber, Workplace Lawyer, right here on Talk Radio 790 KABC.
Four-star General Stanley McChrystal did not mince words about President Trump in a wide-ranging interview with ABC's This Week, saying the president is dishonest and immoral, and adding he could not work for Trump. He pointed to tomorrow's exit of General James Mattis.
Walking away from all the responsibility he feels for every service member in our forces, and he does so in a public way like that, we ought to stop and say, okay, why did he do it? We ought to ask what kind of commander-in-chief he had that Jim Mattis, the good Marine, felt he had to walk away.
Would McChrystal take the job? He put it right out there.
I'd say no. I don't think he tells the truth.
KABC SoCal weather, mostly cloudy overnight with lows in the mid-40s to lower 50s. More news coming up in 30 minutes, continuing coverage at KABC.com. I'm Steve Cumming, Talk Radio 790, KABC News.
This is Behind the Mic with Brad Dalius.
Hey, it's Brad Dalius, host of Behind the Mic, and we're wrapping up your day with your favorite LA sports teams, the latest buzz in national sports, and more, weeknights at 11 on Talk Radio 790 KABC.
The Employment Lawyers Group is a results-driven law firm whose goal is to get the right result for the client. They have represented employees with a high rate of success since 1993 throughout the state of California. They're only paid and if they are able to collect money from the employer, so there's not any upfront fees or costs in order to hire them. They have represented thousands of employees who've been terminated from their jobs, sexually harassed, subjected to employment discrimination, or are owed wages in an individualized or group basis such as a class action. Call 877-525-0700. That's 877-525-0700. They have operators standing by. They can also be reached at employeelawca.com. They have offices throughout Southern California. Hire them and make your workplace problem theirs to solve.
Common sense and justice, the law does not rely. Oh, go on now, go. Pay your lawyer's bill.
Talk Radio 790 KABC. You're listening to the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, a real employee lawyer. And guess what? We have something very special. And it's not Remus Helms or his thing. We have my office on the line with new client calls. We have the wonderful Kelsey on the phone. Are you here?
Yes, I am.
All right. Tell me what calls have come in since I was last at the office, which wasn't very long ago.
Just one. This man was terminated. He did make a complaint about a lead technician treating him differently, and then soon after that he was terminated over a safety violation on not putting shocks on a truck that he wasn't working on.
How was he treated differently?
He said he would yell at him and be impolite.
All right, well, yelling at an employee and being impolite is not illegal in the state of California. It probably wouldn't even be a workers' comp case. And then he's fired for a safety violation, so it does not sound like a good call to me.
Nope.
All right, well, thank you very much for bringing that to my attention.
You're welcome.
All right, bye. We get a lot of calls, and one of the reasons why I don't do calls on this show is they're really boring. And they are just ridiculous. If someone did the safety violation and they caused a safety violation, they should be fired. I think we all can agree with that. And if there's a mistaken belief that he caused a safety violation, but he didn't really cause it, there's case law saying you can fire someone for a mistaken belief. The only way this starts becoming a wrongful termination case is if he's being treated differently for age, sex, race, disability, marital status, I don't think pregnancy because he's a man, sexual orientation, stuff like that, or because he blew the whistle, which means he complained about something illegal, something that is against a statute. A statute is different than I think it's illegal, but I think it's illegal and I have a reasonable basis for believing it's illegal, and being fired for making that complaint might be a case. But I will tell you, if I had these people calling in on this show, they would ramble. They would never get to the point. You would be bored. You would not be getting Remus Helms, Cindy D. You would not be getting the people I have on this show. You wouldn't even get my weird story that I told last week. So please understand, I'm doing you a big favor by not exposing you to these new client callers. They're very rude. They're very hostile a lot of the times. They get mad at my staff a lot of times because they got to get them off the phone. I mean, it's just, they could talk for an hour until they have to go to the bathroom, and there's just no case. And the problem is, we're not therapists. We try to be as understanding as we can to new clients of the state of California, but there are limits. And a lot of these people, they really do need to go and get some kind of help over what happened. The issue is not a legal issue. It's otherwise. And they don't want to do that. A lawyer is not the answer for everything. I'm the first to admit it. A lawyer is there if you've got a real case. You're going to be able to sue in court. You're going to be able to win it, too, because I don't want to get clients in situations where they're not going to win. If I got somebody and they got a marginal case and they're probably going to lose it, I don't want to drag them through this for a year or two or maybe longer to lose their case. The law has changed, so it's very difficult now for employers to get the employees to pay the costs if they lose a discrimination case. But, you know, with wrongful termination, that may not be the case, and you could be looking at having to pay a lot of costs. So it's got to be a good case. And I know what a good case is after doing this for 25 years. I do believe I have screened more new client calls than anyone else in practice. Nobody else has 200 of these people calling in a week. Nobody has the number of emails I have. There are times when I did this nationwide, and you know what's there and what isn't there. And a lot of times people lie to you too. And I think the appropriate time to talk to these people is off air, not on air, because it's confidential. The state bar has requirements. They want all kinds of disclosures. They want the people at the station making a disclosure. They want me making a disclosure. And then it's sort of like, well, okay, you can be on air and you can talk, but is it really in your best interest because your supervisor may hear of this? And then they find out you want to sue. And then your coworker hears this. It's embarrassing. So unfortunately, the reason why we've gone to the format we've gone to in this show is because we have respect for the client, for the confidentiality, for the privacy of the issues, the delicacy of it, and for the listeners, because I don't want to bore the listeners, which is a serious thing. If people are bored, they don't want to listen to this show. I want them to learn about employment law with this being funny, with there being crazy scenarios that they're going to remember. I script these every week, and it takes me a lot of time to script these, but I want to provide the best content possible, and that's why we've got a cult following of this thing on the internet and some very hardcore KABC listeners that call me off air about this show. But let's talk a little bit about the law, because that is what we're supposed to be doing, and I'm sorry if I sound negative, but I'm just being honest about the new client situation. So a lot of laws are coming out. They're bills signed into law. We've got one on sexual harassment that's going to be effective in 2019. It makes void and unenforceable any provision in a contract or settlement agreement that prevents a party from testifying about criminal conduct or sexual harassment in an administrative or judicial proceeding. I don't think this is really different than the law has already been, because it's illegal to say that you settle your sexual harassment case, and so you can't be subpoenaed to go testify about it. I don't really know what the point of this is, but it got signed into law. It's just what the law already provides for it. Another thing, I know some people think I'm too liberal or whatever. I have issues with there being too many labor laws, and I'm the first to say it. I represent employees, but there are way too many laws. There's no way an employer can possibly keep up with all these laws, and there's no way they could understand them. It's hard enough for a practitioner. That's why I was talking to my guest here, Ben Rothman, and I'm saying, I think if you're in employment law, you got to be in employment law, and that's it. You can't be dabbling in anything else. There's too much law.
Well, a lot of these employment cases cross over into personal injury.
How?
Well, for example, you're on the job and a third party comes along and injures you.
Okay, if a third party injures you at work, it's workers' comp against the employer. You could go sue the third party in personal injury, but how often is there a physical injury in a case where someone is suing for unpaid wages by a third party? And if it's a third party, what about sexual harassment? Because we sue the third party.
Well, you get a lot of these restaurant cases, and those always end with somebody getting beaten up really bad.
I'm kind of hoping not all restaurant cases end with someone getting beaten up pretty bad. Now, I will say that I've had restaurant cases where they make sushi in the shape of the Remus Helms thing. I've had restaurant cases where, what else do they do? They tell pregnant women they're too big to be in the cashier's booth. Bad stuff happens at restaurants, and they're generally not collectible, but I can't imagine every one ends with assault and battery.
Just mine.
Just yours, which are my overflow cases. So this is not looking good.
Starting to connect the dots here.
Another thing I just tell listeners, if there is a call about a workplace fight, I will not take the case. I don't care if the person calling thinks they were in the right. Those never turn out right. People fighting at work should be fired, and you're supposed to avoid it. And it's the same with security officers. If they start getting into a fight, they're supposed to de-escalate, and you can be fired for not de-escalating. Okay, whatever exciting new laws are there? Some of these are not really so new. We have adding a provision making it unlawful for an employer to release an employee in exchange for a bonus, raise, or continued employment agreement if the employee is being forced to release their claims. They can't do that. Okay. I don't think that employers should be conditioning bonuses on releases. I do see that happen, and I think that's wrong. There also is a prohibition on making employers liable for any kind Oh, I'm not going to read that one. All right. You're listening to Karl Gerber, Workplace Lawyer Show. I'm Karl Gerber. I'm a real lawyer, and this is, of course, Talk Radio 790 KABC. I encourage you to call my office about a real case. We're going to be nice to you, but use some discretion. If you got into a fight at work and punch the other person out and they feign it, don't call. You should be fired. 877-525-0700. If you engaged in sexual harassment, don't call me. I don't represent sexual harassers. That's 877-525-0700. If you think you're owed a lot of wages, but you also embezzled a lot of money from your employer and you think maybe the offset is in your favor, please don't call me at 877-525-0700. I take legitimate cases and only legitimate cases. So when we come back, we'll talk more about new laws.
Holidays leave you strapped for cash? How does 4 shots at $1,000 sound?
Lord, that sounds good.
It's the $1,000 payoff on 790 KABC. Starting Thursday, listen for the national keyword weekdays at 6, 9, noon, and 3. Then text it to 95819 for your shot at $1,000 4 times a day.
Ka-ching.
The $1,000 payoff on 790 KABC, because politicians aren't the only ones that should be paid off. Rules and info at KBC.com. And please do not text and drive.
Let's do it. Okay.
O-K-L-L-L. On this week's Uncensored OKLA podcast,
Steve, Jillian, and me, Dorothy, try and get ET's Nichelle Durner a date.
And I reveal that journalists love chaos. The OKLA podcast, free, uncensored, and unmissable.
Download and subscribe for free on iTunes and KABC.com.
790 KABC.
I'm Tiffany Haddish, and I'm a Groupon super user. The holidays may be over, but it's not too late to save big and treat yourself to the gift you actually wanted. You've already got the free app, so whip out your phone and act now with Groupon. Seriously, you've earned it. Act now, treat yourself to massages, facials, or sports and concert tickets. Millions of people are doing it. Why aren't you? Save more while you live more. Act now. Groupon.
O'Reilly. Purchase 5 quarts of Valvoline Max Life High Mileage Motor Oil and a MicroGuard filter for the same price as Valvoline Conventional, just $26.99 at O'Reilly Auto Parts. Extend the life of your engine with Valvoline Max Life. Plus, earn double O Rewards points on this purchase. O'Reilly Auto Parts. Better parts, better prices every day. Limits apply. See store for details.
O'Reilly Auto Parts. The natural habitat of a creepy doll is a horror movie. It can't help being creepy. It's that small, fixed smile and those never-closing eyes, always watching you, plotting, which you're imagining. It's mindless. But when the creepy doll hears that Geico not only saves people money, but also gives them easy access to emergency roadside service through an award-winning app, it knows you should switch. Because yes, switching to Geico is a no-brainer. The only question is, how did the creepy doll move from the bedroom to the hallway? I would get out of the house. The natural habitat of a creepy doll is a horror movie. It can't help being creepy. It's that small, fixed smile and those never-closing eyes, always watching you, plotting, which you're imagining. It's mindless. But when the creepy doll hears that Geico not only saves people money, but also gives them easy access to emergency roadside service through an award-winning app, it knows you should switch. Because yes, switching to Geico is a no-brainer. The only question is, how did the creepy doll move from the bedroom to the hallway? I would get out of the house.
Say there, what's the frequency?
790.
And the letters?
KABC. The Rick D's Dead 40 Podcast.
Wealthy musicians pay a lot of money to a team of business advisors, doctors, even family to make their lives easier. But what happens when those very people become the problem or even the cause of their death? This is the real life and death story of Michael Jackson.
Michael Jackson, How to Murder a King. Now streaming as part of the Rick D's Dead 40 podcast on iTunes, TuneIn, and KABC.com/Dead40.
Who's bad?
News.
I like the way that they report the news.
Talk.
They're honest critics.
Evolve.
It's pretty thought-provoking and it's funny as hell.
790 KABC.
Since 1993, the Employment Lawyers Group has been a consistent force in fighting for the rights of California employees. They've represented thousands of employees in cases in which they've lost their jobs, been sexually harassed, discriminated against at work, or owed wages individually or as a group such as a class action. The Employment Lawyers Group has maintained a high win rate and a serious record before the California courts. Please call 877-525-0700 for an experienced work lawyer. That's 877-525-0700. They have call takers standing by. Online, research the firm at worklawyerca.com. They have offices throughout Southern California. If you hire the Employment Lawyers Group, your legal problem becomes theirs to solve.
A statute might apply to protect me if I did. But common law, commonly does not forbid.
Talk Radio 790 KBC. You're listening to the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, and that's still my problem. And we're still broadcasting from downtown, trendy Culver City, if you can believe that, where there are more construction cranes than there are in Phoenix, and that really is true. Next week, we're going to be back to the real funny stuff, but it's kind of hard to get all these actors in end of the year. We're talking about real stuff, and I have in studio with me Ben Rothman, who does my overflow cases, who is a real lawyer who I guess had a class with Ben Shapiro when he was at UCLA, and Ben Shapiro was 11 years old. At any rate, one of the new laws that is coming on the books this year is expanding the statute of limitation. I think most people know statute of limitation means that that's the period of time in which you have to sue. The statute of limitation is getting extended for sexual assault to 10 years. That is the longest civil statute of limitations I'm personally aware of. I don't know about sex crimes with children. That may also be a long one, but this is going to be a 10-year statute, or 3 years after the plaintiff discovered or reasonably should have discovered injury as a result of the assault. Ben, what do you think about that statute?
Nothing.
Okay. I like the idea that people are not being cut off too early to sue. I think 10 years is kind of a long time, and again, I represent employees, but there does need to be fairness in the legal system. I have some concerns, especially when it comes to assault, because assault is not even touching somebody. You may not realize that your hand got very close to a woman's buttocks or something like that, and it may not have been an intent to even touch it, and now you're being sued over it at a job you had 9 years ago. And I don't understand how somebody could not have discovered that there was sexual assault within that period, why the 3-year statute wouldn't apply. I don't know, unless you're reviewing footage, for instance, and you realize that somebody grazed a private body part, because sexual assault has to be of the intimate sexual organ, which are breasts, buttocks, and genitals. So I would think you would know if someone came that close in contact. But here's the other problem I see with this. Assault requires that there be an almost offensive touch. And how could it be offensive if you see this on video for the first time? I'm having some trouble understanding under this scenario, if this is an adult, how they would not know that they were sexually assaulted for 10 years.
Maybe they were drugged.
Okay, but then again, how do they find out this is happening?
I have no idea. I'd be more concerned about preserving evidence after 9 years. How are you going to prove it?
Well, most of these cases are involved witness testimony. I guess it's the same thing as the hearings we had this summer and, where the witness is now. But I've had cases where people were drugged and sexually battered more so. Battery is when there's actually a touch. The assault is when there isn't a touch. But I have had cases where people are drugged. And I had one where, the woman realized something happened there very quickly. I guess this could happen if you're drugged, but then this comes up. How are you just realizing this more than 3 years later and 9 years later? Someone tells you about it. It's a little strange, but I guess it's good that there's a long statute of limitations. 10 years seems a bit long for an adult. I don't know. But you know what? There's no reason to be sexually assaulting anyone. So maybe the best thing is just don't even think about doing it and you won't get sued. Right?
Sounds good.
I don't know. So we have another one that interests me. It's on-call rest breaks. And this is a situation where the legislature has decided that a case that was decided is over with unfavorable ruling and it effectually overturns it. So that can happen sometimes, and this bill provides an industry-specific exception to the California Supreme Court's recent unfavorable ruling in Augusta versus ABM, which held that employees cannot be required to remain on call during rest breaks. Now, I guess that's an unfavorable ruling to employers. To employees, you don't really want to be on call on a rest break. So now I guess it depends what side of the coin you're on. It sounds pretty unfavorable that a petroleum worker on a rest break can not get the rest break, but I don't know. This is an example of if there is enough money to fight something, I guess a bill gets put into effect. But I gotta say something, you don't really want employees not getting any breaks. It's very hard to do a job for 18 or 24 even 12 hours. And a lot of these cases, especially in the petroleum industry, and I have a lot of them because I really do a lot of cases in Kern County and Bakersfield, those are not 12-hour days. They can be 24-hour or 36-hour shifts. I think those people need to get breaks and they need to be attentive. They're doing a very dangerous job. It's not only dangerous to their health, but it could be dangerous and cause explosions to other people. And I had one of those cases earlier this year where it was petroleum, and the employers are, he's not on call, and this guy's job is servicing this equipment, and of course, if it's not serviced and you don't come out and respond immediately, you've got oil leaking, oil exploding, fires happening. Come on, and I tell you, come on, you want the jury to hear that your employer is saying, I've got a contract to go service all these petroleum industry clients, and we don't really need to get there very quickly, and you can just come the next day, and the oil's just going into the ground, and it's no biggie. There's all this environmental contamination. So I think sometimes employers need to take a look at the argument they're making. Employees do too, because again, bad arguments that no one is going to go for are not going to be the winning arguments on both sides. There needs to be a modicum of reasonableness on this. And for me, I am very reasonable. I actually don't like to fight things that I feel I'm going to lose. I don't want to be the Dumas that's just got the case where I'm fighting things just to irk the other lawyer and that sort of thing. That is a waste of time. It's unprofessional. I also don't like to be taking extreme and bizarre positions. I like to do that on this show because I think it's funny and it's amusing, it's entertaining, but I don't think that's the way to represent a client. Sometimes you do have to take a case of first impression. I have had my share, and I have my share now, but I think the client needs to be told up front they're getting into a situation where we really don't know how it's going to turn out. It's going to take up a lot of their time. Of course, we're doing the case on a contingency, advancing all the cost. Really, the risk is on me, not so much on them, but the cases need to be legitimate is the bottom line, right?
Absolutely.
Have you seen some really illegitimate cases brought by other lawyers?
No, because I'm the one who brings them.
You bring unreasonable cases.
Only reasonable cases.
Okay, good.
I get a lot of phone calls about bathroom breaks.
Yeah?
And I've not yet filed one of those.
Well, if it's a pregnancy situation, I think you got to be vigilant on it. If they're not letting the lady get an extra bathroom break, that's denying a reasonable accommodation. The question is, are bathroom breaks only allowed on your 10-minute breaks? That's the question a lot of employees have.
Well, it's totally unregulated.
I think that under Labor Code Section 6300, and there's several, and 6400, it just goes to an unsafe and unhealthy work environment not to allow people to go to the bathroom. And they need to be able to go to the bathroom. It obviously, if they... I don't want to get into scatology humor. That actually doesn't interest me. A lot of other humor on the show does. But I think you can imagine what happens if someone doesn't go to the bathroom. That's unhealthy to other workers.
It's denial of due process.
Yeah, really, even though it's a private employee. But it also could present safety problems to employees. People could get bladder infections. I just don't think employers can say you only can take a restroom break at your rest break.
Well, you would think. I mean, it's called a restroom.
I've had a diabetic case. I've had different disabilities where people need to use the bathroom more frequently, pregnancy and disabilities like that. kidney problems. The one that may come to mind for some of our listeners, I gotta say, I'm not that young anymore either. I was 24 when I got licensed, but I've been licensed 25 years. We do need to take more bathroom breaks sometimes as you get older, and there's that age discrimination if you're not being allowed frequent bathroom breaks. I know some people, when they get a lot older, have reasons, men do, prostate issues, why they need to take more frequent bathroom breaks.
It's more of a disability discrimination in that case, if they have some kind of prostate condition.
Well, an age plus, I mean, I don't know if it just becomes we want people who don't have to go to the bathroom working for us. I don't know if you want employees quite that anal. All right, you're listening to Karl Gerber, Workplace Lawyer Show. I'm Karl Gerber. We've had Ben Rothman, who does my overflow cases, on tonight. I would like you to call me at the office at 877-525-0700 if you have an employment case. Once again, 877-525-0700. Again, legitimate cases, 877-525-0700. I don't file cases for the sake of filing them. I file them because what happened was wrong and the employee needs to be compensated, and the employer was wrong. So please call me about those kind of cases. Next week, we'll be back to very funny scripted comedy, okay? Because I know we've got a lot of people listening for that. Thank you for listening to Karl Gerber, Workplace Lawyer Show. And Happy New Year and Merry Christmas if you didn't get to hear me say it last week.
This show furnished by Karl Gerber and Employment Lawyers Group.